everyone. This is January the 17th, 2024, very auspicious year. We've had a very transitional holiday period with lots happening on the planet. We are still here, moving forward, helping everyone, and we're moving together to create a new world. We are blessed and privileged today to have Randall Hillner with us, our speaker. And we just heard from one of our clients and good friends, Steve, in New Zealand. He's from California originally. And he was saying that this is very much needed, that he was appreciating the contribution of the education about freedom and the provision of instruments and tools, vehicles such as the Natural Law Trust for the protection of assets and the removal of our support from the old system that was not good for people. We are a project of La Vérité, which means the truth in French. House of Freedom International Natural Law Trust is our topic today. And Liberty Debt Elimination System is available to Americans for those who have debts in US banks, debts that are unsecured in the credit card or student loan area. And we have affiliations and special offers with various other types of information available. We are members of the Worldwide Charter for International Commerce. We encourage you to look at that on the website if you haven't already. It has a list of 9 principles that we adhere to. Today, January 17th, our next webinar is to be determined. Randall is thinking maybe we might do them sooner instead of every 3 months, maybe every 2, or even maybe a follow-up next month. So we'll let you know. We'll let you know when that is decided. For those calling in or who need a phone number, we have 360-200-7521. House-of-freedom-trust.com is one of the access points to our website. My name is Tansen Fairmont. I'm the founder. I'm a consultant in bank instruments programs, speaker on radio shows and former investment seminars, and an author of a couple of books. Randall Hillner is the head of our trust department and the creator of the House of Freedom Trusts, the White Light Unlimited, One People's Public Trust, and the crafter of the trust that many clients are using and that you can use if you're not already. The crafter of a state-of-the-art trust that we're going to be talking about today that has benefits beyond anything we've ever seen in the world. Dominique Hackett is our good friend and associate who works with us. Dominique has a background, as you can see, in both statutory law and common law, having been CFO of a corporation and worked with accounting. She's writing an accounting book for trusts and has provided consultation and some services to trust clients. Laurel White works with us as well. She's been a professional trustee and a protege and has a variety of fields of experience and knowledge and talent. So today's topic, 2024, your year to put your house in order. House meaning asset protection. Randall, I would like you to please go ahead.
Well, Happy New Year, everyone. Welcome back. I'm glad to be here myself, and I'm really grateful that I can be here. And I'm hoping that this year is a really potent year to get out a lot of information on how the natural law trusts are going to work for you and for your relatives and your community, etc. And so we're going to work on breaking it down into different pieces and categories. And then by the time we have today and maybe next month, you're going to have a basis for being able to know what your trust is going to do, how to work it yourself, and how to make it productive all the way into infinity if you want to do that.
Randall, if you could please move your camera down so your the view of you goes up. No, the other way. There we go. There we go. Yeah, there we go. Thank you. Much better.
I can't see myself.
I know this Zoom doesn't show it.
So, but the idea is we're going to make a whole pie out of the pieces that we're going to do today, and possibly next month, or certainly the month after that. But I'm really excited about learning that. And one of the things that I'm going to do is I'm going to take excerpts from a handbook that was written 30, 40 years ago that we've come across numerous times. I've used it besides the trust law books that way down my shelves and sometimes way down my brain. This is put together by somebody who explored the world of trust, and he compared statutory and common law or natural law trust. And the decisive decision that he's made just clearly indicates how important it is to leave the statutory process as much as possible and get into your right, your unalienable right to contract. So the master, I'm just the messenger. The master is really somebody that's been around for a long time. So this is from Carl Weiss, and these are excerpts from his gospel. Really, it's like a Bible in a sense, because if you get this, you'll have what you need. Okay, let's travel on to the basic paradigm. Slide, please. We have a slide.
Are you seeing it? It shows excerpts from the expert.
I just ran through it. I'm sorry, the next slide.
Okay.
Okay, so that expert and the work that we've done in all this time has been how to classify the trust. So when you're creating a trust, you're going to create it because you declare it and it's written, or you express it and it's oral. And the express trust, or the expression, the idea of orally or written, is very much more important than if you imply it. The act of a party says, oh, I'm thinking about doing a trust, but I'm not sure quite how to do it. Whereas when you express it in more detail, which is what you get when we work together, you get to have an oral understanding, and you also get to have all the written pieces that you need to make it all happen. You can do the same thing with an implied trust, but just out, it's too nebulous. So what you want is we have, depending on how you want your trust document written, we have 30 to 40 pages of document that gets detailed information on how to make the trust work and how it works for you. So you have it by an act of a party, which is basically you come to BIC, you say, hey, I've heard about how to protect my assets with a trust. What can you tell me about it? And that's done by us, and that's by the act of a party, because you are a party with BIC. If it's an act of law, it's usually because something's happened to you, and it results from, let's say in the case of my demise, I want this to happen. That's where I'm not acting as a party, but the law, I'm putting down the law that will take effect when something happens to me and I bow out. So you have two aspects of it, the party and you have by law. And so we want to talk about the differences between the two and how the natural law trust works. Okay, next slide, please. Okay, so the natural law trust it's a combination of common law, natural law, common law, Roman law. I mean, there's so much depth to basically a trust that I'm sure that a trust in some form has been in every social realm that has any financial process at all. And it started way back when, went to Rome, went to Greece, came to Europe, then came over to England. The British developed it and refined it even more. And then those people that came to the US and created a whole new paradigm over here and created the United States of America, which is a trust. and the people are the trustees. So they've taken that idea of a trust and put it into form. And the federal government is really a trust that's supposed to take care of you, the beneficiary. And how much does that happen? So we won't deal into the politics of that. But the idea is you separate yourself from the asset. You have a trustee to take care of it, and you have a beneficiary that receives money or whatever it is that the grantor wanted to receive for the benefit of that person. It's a beautiful process. And we have to get that. Back to a lawyer. I heard a comment earlier on the earlier show. How about attorneys and how it's hard to go there. And it is. It's like right in the front. This guy says, "Oh, attorneys, they're supposed to be learned in the law, but really they don't have any learning for trust. They're not taught that in trust in law school." And attorney Johnson, a long time ago, said that the attorney in French means word twister. So there you go. How's the attorney going to twist your words to suit his benefit? We want you to be able to have straight words and choose the words that you want in the document that's going to be yours. And there's no statutory legislation to come between it, because federal law protects us. Article 1, Section 10, the Constitution says that your right to contract is unalienable. You have a right to contract, and that's what our natural law trust is. It's your right to contract, and it's not exempt. It's not even, it's not even an example for the exemption under Title 26 for filing a tax return, because it's a contract. It's not a cohesion with the federal government. So that's the idea of getting a trust. It's based on common law and natural law. You can't win without it. So next slide, please. Okay, I'm sorry. I got lost. Anyway, what we have is the other part, the next part of the process in setting up a trust is must have some way to fund it. You have to have something to fund it. Now that funding can be real estate or gold or silver, but anything's called lawful money. And the lawful money today, truly and originally, was only gold or silver. And the original trusts were only set up to handle real estate because the corporations that were first initiated in the US when it was first starting didn't have the ability to hold land. They could only hold a business. So they started the concept of a trust to hold land. In the early days, it was called the Massachusetts Land Trust. And then it began to, as time went on and history and law began to take precedent and help support that process, then it became steeped in law, and that real estate was one aspect of it. And then the trust began to be able to have gold and silver and have other commodities to hold as their funding process. And so the beneficiaries just didn't have to worry about getting land, but they had lawful money and they could do investments, and any corpus, any commodity that they wanted, they can go and do that. And they can do business all over the world now. So you have a trust that you've initiated in whatever situs you are, any domicile that you have. It's based in the USA, perhaps. We have ones that are based in Europe as well. And you take it here, you establish your precedent here, and you can take it all over the world. If I'm a trustee for you, I'm going to send you all over the world to look for possible and potential investments to make the corpus. Excuse me. Sorry. So we have real estate, gold, and silver, all lawful money, all commodities that are lawful and readily available. And the idea is to be able to use them and be out of the net of the corporate process. We can talk about that some more as well. Okay, so next slide, please. Okay, so now here's some nice characteristics of what is going to separate us and allow natural law trust to really cultivate the aspect. We're going to have two ways to have it's shown that the trustees or the grantors have come in and they truly have separated their assets because they have given a certificate to the beneficiaries. So the grantor or the trustees come in, depending on what we're going to do with that, and we'll go into that in a little bit. But the trust certificate indicates to the beneficiary how much asset, how much percentage of the assets in the trust are due to him at either the discretion of the trustees, which can be monthly payment, yearly payments, or it can be that there's no payout until the end of the trust. So that's all the possibilities that exist. And one of the ways you do that is if we have a person that comes in and wants to be the grantor of the trust, and he doesn't want to be the trustee. He's done his business. He's been in business forever. Now he just wants to relax. So he comes in and he hires you or somebody as trustees that he trusts with his estate, and they have a fiduciary responsibility to give him as a beneficiary trust certificates. And those would be units, what we call units of beneficial interest, and therefore a beneficiary that has been basically a grantor and funded the trust with his estate. So how does that what does that mean to the control test? What that means is that he's come in, he's hired somebody independent, non-related to him, and they have taken lawful legal title to his asset, and they have given him in return, they have given him units of beneficial interest. Could be 100%, it could be a percentage. If he has a family, he has a wife, he might give 50-50 to him and his wife, and then 25 and 25 to the children, or 25 each. So that's one of the ways. Another way that we have it set up, which is really good, is we may have a grantor, a nominee grantor. We have that service here, or you may be able to have, you may have a friend that's willing to be a nominee grantor, and they grant the trust, and you are going to fund it with your money, your asset. You're going to be the trustee, and you're going to give the beneficiary to, to somebody else. So I'm sorry, I got lost there. We have the TCUs, which is the trust capital units. I'm sorry, I had to switch. The trust capital units are for somebody that comes in and funds the trust, and they get to have the benefit of that trust as well as the ordinary beneficiaries. So they get a percentage. They get a percentage of the called trust certificate units. The beneficiaries, the ordinary beneficiaries, get the units of beneficial interest, and that is divvied out usually at the end of the process. So what the trust certificate units has done is allowed our trust, the natural law trust, to not only hold land and commodities, but to also run successful businesses and be set up as a business. So that's a beautiful combination of how to have a powerful impactive process in your asset portfolio. Okay, I guess we'll go to the next slide, please.
Did you want to explain the difference between the UBI and the TCU?
Oh, I thought I did. I thought UBI was the unit of beneficial interest for the beneficiary, and the TCU is the trust certificate units, and that's for somebody that comes in and funds the trust with their money, which is separate from what the beneficiaries are getting as well. So he funds and he gets a percentage of the end as well. Wouldn't just be the beneficiaries. So the grantor may allow this gentleman, a funder, to come in. He funds the business, and the beneficiaries and him, the funder, get a percentage of the portfolio.
Okay, thank you.
Is that what you wanted to hear?
Yes, thank you. Okay.
So trustee duties, powers, God, there's so many. What we have to do is the way we set the trust up is we have that the trustee has no general powers. You have to have it defined. And the more definition and the more detail you have in what powers that the trustees are going to have is the more latitude he actually has, because whatever he does is written within the trust document. And so that trust document covers what he does. And he does it with prudence and best effort. If he does the best effort that he can do, and it's the prudence of an ordinary man running a successful business, then he's really out of any liability. And that's the really good thing that you also have to cover within the trust document, because you have to allow the trustee to act judiciously and with discretion on his powers and duties, as long as he understands what that best effort is. And so he knows that he can do that, but he won't be held liable as long as he's made a best effort to make that happen. And if anything happens, if there's a miscalculation or something, but he's done his job, then the people that want to get repaid because of that mistake have to go to the trust rather than the trustee. As long as he's been upfront and not created a breach of contract, breach of trust, then he's outside of that liability, and the funds have to come from the trust. Now that's what makes the trust really important. One is the fiduciary responsibility for the trustee. So that keeps him in line. He wants to stay in line. He doesn't want to breach those walls, and he does a best effort, and he uses a great deal of discretion and prudence to capture the whole picture, and creates a sense of a process where the beneficiaries have latitude and great benefit from what they receive, and the trustees have a latitude and discretion on how to serve the beneficiaries in their best capacity. Okay, next slide, please. Liabilities and privileges. So we're just talking about that, how we're going to have the liabilities are coming from if there's a misstep. So liabilities basically come from a breach of trust. You haven't you have the liabilities and privileges. So you got you have the inherent right to be reimbursed. This is a trustee that go through the privileges first. You can be paid for the services that you do as a trustee. You have the right to live in the premises if it's appropriate and it's in the document to do. You have the privilege to pay for solicitors or any third party or the trust for the benefit of the trust and ultimately the benefit of the beneficiaries. And then the right to apply to a court of equity if there's a misunderstanding. And so rather than going to a statutory court where the court process might be geared to the statutory realm, you find a court of equity where the performance commands payment. So in other words, when you're in equity, equity demands payment, demands fulfillment of that trust. Okay, and then get to some of the powers. So sometimes one of the things that's important when you take on the role of a trustee is how you sign and how you form the contracts with the contract. So in other words, when you're the owner of any asset or any business, and you're running the show, you sign as your name. When you take on the role as a trustee, you need to make it clear that when you sign a document or for anything that has to do with the trust and a check as well, any checks, any bank accounts, anything that deals with the trust, that you're always signing as trustee or as accounting process, whatever. Make sure that there's a separation and you know that you're signing as trustee. Sometimes you're going to have a form, and on it you're going to sign as the owner or the grantor, and you're going to sign just your name. And then other places you're going to sign as trustee, and you'll see that under your name is as trustee. So just be aware when you get the liabilities and the privileges that you understand them, and you'll find that the document contains all of that. The last slide where the powers, this slide with the privileges and liabilities, and the next slide, which we'll go into now. Next slide, please. Just make sure that you're always running as the trustee for the trust. Okay, so here's a summation. Trustees have the absolute rights and privileges to engage in interstate commerce and actually foreign correspondence commerce anywhere. So we have clients here, clients in Asia, Europe, not China yet, Australia, New Zealand, South America, Europe, UK in particular. I have clients in Africa. And so we can work, once you do it, you can work that document anywhere that a common law, the right to contract, is held. Any country that holds your right to contract will allow a trust document to persevere, because it's not a trust document per se, it's a contract between 2 or 3 people. The difference in the corporation is that they have rights and privileges, but it's highly regulated and restricted by statutory regulation. So here you're going into a process where, oh, you get some privilege, but basically, if you've heard of the piercing the corporate veil, if you do something wrong and the veil is pierced, then they can come after you because you're the owner of the corporate stock. The trustee is only holding the lawful title, and the benefit goes to somebody else. As a corporate officer, you can sell that stock, and so that stock can be sued, that stock can be privileged and be put into the suit. So be really aware the difference between the trust and the corporation. It doesn't mean that you can't use your corporations now. I have a number of clients that we're working where they have an LLC or they have an S Corp. And what we're doing is we're using the trust to be the main partner, the main owner of that LLC or corporation. And so becomes a pass-through entity, and it passes right through into the trust. And the trust is out of that statutory process into the private realm. So be aware of that. Doesn't mean you can't keep your corporation and the LLC going, especially if it's already successful and it has a name for itself, then you keep the name and you just change ownership. And the slide for the different is going to be on another video. Townsend?
What's that?
The slide for the difference, do you have that slide? Or do they have to go to the October session?
Yeah,
Or do
for
you
all
want
the
me to
other
show it?
slides, all the other slides on the difference between the trust and the corporate benefits, go to the October 18th, 2023 webinar.
Okay, can you see this?
Yes, but lift it up higher. And a little bit further back, away from the camera. There you go. Okay, that's visible. But we
Oh.
can't necessarily read it because it's small.
Okay, so I'll read a few, but basically the it's under equity. The trust is under equity, whereas a corporation is under legislation. That's a big difference between real lawful money and the corporate structure, which is, as we know, US government corp and fiat currency, et cetera. And that's what we talked about. That was part of the conversation I heard earlier when I came in the back door. So we have to honor that. And what we see is that I won't even go into it. I'm going to present a slide next month, maybe, or whenever we do it, we come back. I'll have a slide specifically for this, and that's where we'll start. We'll start next time with this particular diagram, and we'll recap this differences between the trustees and the corporate officers, because I think this is the most vital part, and this is what's going to help pull you into the sovereign aspect of having your trust in order, having your stuff with the IRS in order, if you haven't done that, having all your things that the VIC offers on their webpage. Have you done your debt elimination? If that's costing you anything that's on there. So I really highly encourage you to get onto that VIC webpage and go to some of these different videos and find out what's available. And of course, all the older videos that we've done in the past are all posted up there. And then next time we meet, we're going to have a really kick bang show, because I want to delve into commerce and how the trust and commerce far outweighs the use of corporations in commerce, and how much more freedom that you have with the use of a trust than the use of a corporation. So I guess on that light, let's turn it over to questions and answers. Does
We
that
have a
work?
couple more slides.
Oh, which was?
Okay, this one, understanding commerce.
Oh, I wanted to leave this for next week. How much time have we done?
We've done about 35 minutes.
I really wanted to take a half an hour on this commerce. I would really like to save this next time, because I'd like to recap the slide and really do a big bang on the commerce. Would that work for everybody?
Okay.
Let's put it into a question and answer, and I'll respond to what I just said with that.
And
Okay?
what about this one? Keeping details, paper trail.
Let's do it next week.
All right.
So, questions? Yes, questions will get us to the light at the end of the tunnel.
Okay, everyone, you can put your questions in chat, or if you're on the phone, press *9, or if you have a video screen, you can click on the raise hand icon. So Kristen is saying, can you please explain equity more? It seems like it is a synonym for several things.
Together, because originally, early days, and then as sailing took over and people started going around the world, then it developed into what's called a commerce. So in the beginning, you have trading, and equity means that when you trade something, you have to trade with a commodity that's as equitable as what you give. And so if I give you 10 pounds of wool and you give me a pound of gold, and I accept that as real money, then I accept that. And that's a real trade. When I give you 10 pounds of wool and you give me $10 in fiat currency, then that's not a complete trade. That's not real money for me. I have to go redo that somewhere else. Whereas gold or silver is not recorded, and I can use that any way I want. So I just want to be clear that when you're working with equity, you want to work as closely with real substance versus fiat stuff, if that makes sense, I hope.
You know, Dominique is enrolled in a course now to study more in depth, and she's already been studying equity for several years.
Yep.
equity
Yeah.
law.
I think we're going to do that together. I signed up with her. So yes, it's an important aspect, but when you know equity, then it's such a smooth sailing ship when you combine it with the use of a trust. How can you go wrong? You've separated your assets out. You have a trust over here. It belongs, you have an equitable commodity in here. You have a house or you have gold or silver. And over here you have your separation, you have your trust, and it all goes in there and it's not in your pocket. So it's protected. Each one is like a wheel around and holding this whole concept together. And that's why I want to have this next week. I'm really excited about it. So questions, please. If I
Okay,
had missed.
so Margie is asking if I am grantor and trustee, does it matter whether I am the first or second adverse trustee?
No, trustees or co-trustees. If you're an adverse trustee, it just means that you're not related. Co-trustee is either related or non-related. An adverse trustee would be somebody that's not related. And so there's not that what they talk about is the ability to sway a trustee because you're related by certain parameters. So what they're trying to do is have an independent trustee.
And isn't it better to have a nominee grantor rather than the grantor be the trustee?
It doesn't matter. Yes, you can be a grantor and a trustee if you're not a beneficiary. I have clients that come and they are granting this trust and funding it with their asset, and they're the trustee, and their grandchildren are the beneficiaries. So all they need is the successor, and it's set to go. So it works that way. You can be a trustee, but not be a major beneficiary. So there's three intricate little aspects there. And if anybody has a question about that, please write to us and I'll delve into it specifically. In fact, we can put it on a list and I'll put it in for next session that we have.
Okay. Nikita is asking, can a trust be 100% share owner of an LLC? Any restrictions where state-wise, where the states, well,
Yes,
which state the LLC is in?
it doesn't matter what states they're in, but some states, if you're a single owner, it can't be a pass through. It has to be taxed to whoever's owning it. If you have two or more, then it's considered a pass through and it would go into the trust and the minor owner, and then the trust absorbs it and it does that its own work. So the LLC is just a pass-through entity. If you have one and it's a name and it's out there and it serves you, you don't have to disband it. Just I'll teach you how to have the trust own that LLC or the corporation.
And she's asking if it's recommended for the trust to own 100% of the LLC's assets.
No, you can't. I just said if you're the single owner, then they're going to tax the LLC because they're going to tax the owner. Whereas if you have two or more owners, it passes through the LLC and goes to the owners. So the ideal would be to have a trust be an owner and you be an owner, and the percentage is up to you, 50% for each. Or when I used the LLC, I used 90% for the trust, and my wife and I used 5% each for us. And it worked really well and it was fine. So it's a choice. And as long as you know both parameters, if you haven't started yet, forego the LLC and just do the trust. And we can show you how to do that as well.
Well, thank you.
That's,
Kimberly's asking, did the government put all our real estate in trust? And should we be acting as executors and administering our estates, or acting as beneficiaries and letting them administrate the estates for our beneficial interest?
well, it's up to you. If you want to have a allodial title, which is really difficult to get, I don't know a lot of success rate there. There's some. And you have to go all the way back to the original land trust. And when you go back to the original land trust, you see that the Britain bought the land from the Indians, or they basically took over the U.S., America, and they said they own it. And then they, in order to have a allodial title, they granted the governor of each area a certain percentage that he could give away to landowners. And it kept going out and being dispersed to that. So nobody, from there on, nobody had true title to the land. True title to the land belonged all the way back to basically King George. So he's the true owner, and the Bank of London, basically the Queen of England, owns America because they have the original title. They took it from the Indians. There's a whole alliance now in Canada and US, alliance of Indian tribes trying to take back and get the original land title to their land. So you can go back that far, but the ideal is if you can put it in trust, get rid of your mortgage, put it in trust, base your assets, make money without having to be involved with the IRS, you can make it happen. And you can keep that land inviolable because you can put it in its own trust and nobody can come onto it without a court of equity subpoena from a judge. And then the trustees still can say, nope, sorry, you can't come on. This is a contract between us and the landowners, and you're statutory and you don't belong here. So if you have more questions about that, pack those questions up and send them to Townsend and we'll put it in the seminar for next time. This is pulling a bunch of stuff together that I'm very excited about.
And Kim is
Okay.
also asking, does a trust have a legal personality in England or only in the US?
Trust has a legal personality here. I don't know. I'm sure it has in England because it's its own entity. It's not a person and it's not a corporation. It's its own kind of entity. It's treated, what did I say? Treated as its own entity. It's not a person. So it is different than a corporation and it is different than a person.
Okay, thank you. And Keys is asking, hello, am I correct in saying that the Natural Law Trust is not subject to the recent statutory requirements to file a BOI form, which is beneficiary ownership form?
That's a statutory trust that would have to file out. But if you have a natural law trust, you're not, this is statutory, you're not in that statutory process.
Exactly. And Henry's asking, why type of trust? Maybe he means what type of trust are you referring to, revocable or irrevocable?
Well, I only talk about irrevocable trust. That's the only thing that has value. The only thing a revocable trust is possibly avoid probate, and that's only if the estate is under such a value. It's good because for married couples, it allows them to have control. They can a brokerage house gives interest. I'm sorry. Question?
That was saying recording in progress. That was
Okay.
an automated.
So yeah, that's up to you. Like I said, brokerage house interest, bank is a non-interest. It really doesn't matter because your trust is outside of that statutory realm.
Tracy says,
And you need to realize that even though this whole thing is that one of the powers in the trust document is the ability to work in the fiat currency commerce world. So we have the ability to use what's present in everyday commerce. We don't have to be confined to one or the other. So just know that that's what the trust supports you to do. Okay.
okay.
Question.
Tracy asks, if a trust needs a non-interest bearing checking account, what type of EIN does it need?
It doesn't matter what type you get. If you If you go online, you're going to be confined to a certain amount of check marks. So you want to be careful there. You're basically going to say irrevocable trust. I don't want to give the details because I can't see. But if you go online, you're limited in what you can do. Whereas if you get the form, the EIN number for the form is a specific avenue of what you're going to check. And if you hold on 1 second. I think Tanzan is trying to get a hold of me. Can somebody hook in and see if Tanzan is back online?
See if he's in the participant list.
Okay, so how about we've got that. What else is important to anybody?
Let's see. The next question, can one trust be the beneficiary of another to create layers or tiers? And at the top of the tier, the beneficiary is a person?
Yes. Yes, we can have a person creates a trust, that trust creates another trust. What happens is that along the way, each time a new trust happens, there has to be at least one new different trustee. That's all. Just remember that. That same person can trickle out 2, 3, 4 trusts, depends on what you want.
Matthias asks, can my NLT trust have accounts in multiple countries, like a US EIN and a Swiss corresponding registration?
Yes, we just worked on a couple of our clients in UK. We worked on, I sent an inquiry as what was needed in the banks over there, and I've got 2 or 3 different responses, and they're all basically similar. And it's minimum what you need. You take the document and a few IDs, and you go to a bank of your choice. We have a couple of recommendations if you're in the UK, and we can help you with that. But that's basically all you need is a trust document. When you get the trust, you will get instructions of what to take to the bank. And so we just work with that. And we have specific ways for different banks and for different countries. So if any of you have specific questions, don't hesitate to drop an email. If you don't have my email, then drop it through the BIC office. Okay.
Okay. Guardian asks, do we need to get an IRS 98 foreign EIN to set up the trust?
No, I don't know that element of a foreign, you're not a foreign grantor. You're a foreign grantor if you have claimed or you have your paperwork that you are not a US citizen. So I would be really careful that because I think the 98 is for a foreign entity or a foreign person. And yes, if you're out of the system, you're foreign to the US, but just be aware that sometimes that's what that means. And I don't think it's necessary. I've done multiple EINs for multiple trusts with different addresses, and it doesn't matter. It's just the number that the banks need because the banks are controlled by the IRS and they won't allow you to open up an account without a number, at least in the US.
Okay.
Now, we add to that is there are apparently I have 2 or 3 elements, 2 or 3 that are getting ready to open private banks again, and it's getting close to for the ability to have true sovereign citizens or people that are out extracted from the statutory process that we can have real banks and real money. So we're looking forward to that.
Okay, Margie asks, in Australia and likely other Commonwealth countries, there's a notation on the property title saying that the Crown has a lien over the land. So in exchanging a property title into a natural law trust, does the lien affect the ability to exchange property into the trust?
I can't see how that would. They may have a permanent lien on the land, but that doesn't mean you can't. Let me mute for a second. Hold on. Okay, I'm back. Can everybody hear?
We can hear you. Do you see Tanzan? Can you bring him back in?
I have no control. I'm sorry.
Okay. Nope, that's fine.
He's the one that's setting it up. Now let me see.
Christian. Hmm.
Oh, we have a lot of people. Thank you very much. Okay, let's just hear the question.
Okay, Christian says about allodial title. I'm not sure if I pronounced that right.
Allodial.
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 About allodial title. Why can British royalty give out a title for land they stole? They stole. But my point is, if their claim is illegitimate, why do we still respect it today?
Because people don't know. They've just created clouds and clouds and clouds of title. And so unless you're really savvy, you're not going to know that the queen. And so until the people rise up and say, you don't own this land anymore, it belongs to the people, we're not going to get anywhere. And I don't have a solution to that. I've been dealing with this for 30, 40 years, and it seems like there's avenues of progression and then somehow it gets left. So I'm really looking forward to the day when you can have a allodial title to your property, and the trust and the corporation sole are two of your ministry. If you truly have a spiritual endeavor, your ministry and a natural law trust can give you the best protection for whatever commodity or asset you have in today's world. And that's all we need to emphasize is a trust and your spiritual mission. You get it in place and you're set. Okay, another question.
Okay, Mata says a bit of confusion regarding trust as a member of the LLC. If the trust as a member doesn't file a tax return, does the non-trust member have to file a return? If so, isn't that a problem for a non-taxpayer?
I'm going to say no to that, but I want to put some circles around that. First of all, we're going to have the LLC is a taxable entity. It's a corporate entity, so it's required to file a tax return, whether or not the owner is a trust or a trust and people. So it doesn't matter about the LLC. The LLC is going to have to file a return, but it's going to show zero tax liability because all of its money is going to go to the trust and or multiple owners. Okay, that makes sense? Okay, so that's easily done. That can be done at the corporation, or it can be done with the LLC. If you've already got your storefront and a name for your business, then just stay with it and we'll have the trust be the owner. If you're just starting, then something to think about is having the trust be the storefront, and then we'll have a secondary trust to be in the private realm. So we can do all of that with BIC. Okay, question.
Tracy asks if some of the participants in a trust have dual citizenship, may they get a 98 form for banking?
You mean individually or is it as a group? In other words, didn't quite understand that question. Say it again, please.
If some of the participants in a trust have dual citizenship, may they get a 98 form for banking?
But why would, okay, what participants in what part of the play are you doing? Because the EIN number belongs to the trust, not to the participants. So the trustees already have a social security number or an ID number. And the trust needs to get an EIN number for the banking purposes, but that's all that's needed. Make sense?
Okay, thank you. Steve asks, is BIC still doing the American Passport Program? Do you need the ROE and ICC done beforehand?
The state, all of that can be in sequence or it can be around it. In other words, what I would do first is make sure your personal stuff is together. So if you have intention to file an ROE or whatever it is that you're going to extract yourself from the system, you start there. You have your trust in place. You get your ROE, you get that set up. If you have a ministry, get that set up. And then whoever's in the trust, whoever the participants are in the trust, has nothing to do with the number that is there for getting the bank account open. And trustees can be somebody from Russia, can be somebody from the U.S. It can be both. It can be three trustees, U.S., French, and Canadian, if they can all get along. So just a matter of what it is that you need. Okay, next.
Okay, let's see, one moment. Okay, I went into a TD Bank to inquire about opening an account for the trust. They say new requirements to request viewing the entire trust document instead of just the indenture. Is there a way around this?
Well, when I walk into the bank, I have the full trust document. I let them see the whole thing, but I have the minutes are clipped shut so that it's private, and then I leave a copy with specific pages in it just for the banker for their records, and then it goes from there. And remember that you may have to walk. Sometimes banks don't want to deal with our trust because they're so used to statutory process that it frightens them, and you have to walk around maybe. But ultimately, when you find a good banker, he's somebody that knows that you know what you're talking about, and it would be somebody to value. Okay.
Okay. Sister Love says, can you create trusts for people? Do you guide them, excuse me, when you create trusts for people, do you guide them with the whole process so they would know how to create one for themselves in the future rather than just do it all for them?
Well, listen, well, anybody can take our trust and put it in a copy machine and change the names on it, and they have it. But that's not the idea. Is that do you know how to run it successfully? Do you know how to take care of it and make sure the beneficiaries are taken care of? So it's not the document so much; it's the understanding um, of how to make it work, and that's what I'm here for, and other people in BIC. And so, obviously, I've been working with Dominique and Laurel, and so that something happens to me, other people can come in. But the idea is and that's why this document that I'm working on these next 2 months is so important. And I'm going to give you a link that you can all go and get this document on yourself and start to read it. And you maybe on the next month we'll post it, and I'll give you the dynamics of it, and you read it. So when we get together next month, you will be looking at the same document I am, and it will be really eye-opening. And I hope you join me. It's going to be really fun. The more I deal with this and see the simplicity of it and how it really helps people, the more excited I get. Okay, another question?
Okay, Tracy comments to her original question. Let's go back to her original. She says it's as a group that she's asking. This was the question: if some of the participants in a trust have dual citizenship, may they get a 98 form for banking? And she said she's asking as a group.
Uh, but if the 98 number, you would have to, the person that's not a US citizen would have to be the one to apply for a 98 number. So, and that would be okay, but what address you're going to use? to me, a 98 number, I think you may have to have a foreign address. So you'd have to have a mail stop somewhere outside the country that you could use. I'm not sure. I haven't done it that way. So I haven't needed or thought about having to have a 92 number. It can't really help with a lot of experience there.
Okay, Sister Love says her true question was, do you help people understand exactly how the trust works? She
Sure.
asked about creating.
I've created my trust. I'm gonna, if anything, you can ask to be a trustee and go into trustee training with Dominique and me and Laurel. But no, I'm not going to teach you 40 years of my experience. I don't have that much time left.
Okay. Sister Love also asks, can a trust handle all affairs, such as discharging alleged debt, setting off and offsetting debt?
You would have to go through the same mechanism or process that that you do as an individual if it's going to do that. But if the trust is in debt, how did it get there? Was it the trust itself? Was it a failed adventure? Was it a breach of trust by a trustee? So I'd have to know a little bit more information, but basically, that would not be an issue.
Okay, Reggie asks, what is the ROE?
It's called a revocation of election. Some of you know it. It's a new dynamic. It's been around for a number of years and it's come to light and it's had to be refined. It's been 10 years in the making for sure. But basically, it's a way to extract yourself from the election of having to file a 1040 form. You're saying that, you know something, I understand from all the law books that I'm reading that this is really an election and it's voluntary. So I don't really want to volunteer anymore. And here's all the backup that I have that will show you that I can do this and that I don't have to volunteer anymore. And so please strike my name from the record books. So that's called a revocation of election. And that is available, I believe, on the BIC website. And the people that are helping with that, I think there are two versions. One, you can do on your own if you have enough. And two is that there's a woman named Kelly Alexander that will help you on a personal level to work your way through that. Or also Charles Miller is involved very much with that. And he's a very amazing expert on that whole process. So between Charles and Kelly and myself, we can make it happen for you. Okay, next.
Okay, thank you. This is the final question, Sister Love. Does a trust use fiat currency or negotiable instruments such as a bill of exchange, accepted for value, and promissory notes, etc.?
Can it accept them? Did you say?
Does a trust use fiat currency or negotiable instruments?
Sure. It uses whatever a normal human being, live human being can use. So because we're stuck, we don't have a choice. If you go to the supermarket, they're not going to take your gold. So we have to just use what's available, and that is just, trading one form for another. So the idea is to stay as away from the statutory process, but use whatever is needed to make your life and your business successful.
Okay. She also, the last part of her question was, is it correct a trust cannot sue or be sued?
No, that's not true. In order to function in commerce, you need to sue or be sued. Because trusts make mistakes, trustees make mistakes, so it has to. And if the trustee hires a third party and they don't do the right work, then the trustees have a power to sue and get compensation for the mistake, and vice versa.
Okay, Christian has just posted a question. If only land is in a trust, who pays property tax? The trust or the person that the land is registered with? If the
Well,
trust pays the tax, How is that done, i.e. bank account? Also, if you don't mind, could you go into why we still pay property tax?
Okay. Um, I'll just go on the premise that it's the US. So in the US, all land is basically owned by the Queen. We just discussed that. And so when you pay off if you have a mortgage, that mortgage will go with the land, no matter who owns it. So you own it now, you put it in trust. You're going to go to in the trust document, there's a specific form that will help you do that with instructions that are included. And then you take that form and you take out stuff to the county and you say to the county, this is what I'm doing. I'm transferring this property under my name into the name of this trust. It's re-recorded in the county under the name of the trust. And the property tax will now go to the trustees of the trust. So just make sure that the trustees get that tax bill and the trust pays for the tax bill now rather than you. Okay, is that clear? The trust, once the trust takes title to the land, it will pay the property tax. Okay.
Okay, and Jennifer has just posted a final question. I have transferred my vehicle into an irrevocable trust, but I'm not able to get insurance for it under the trust using my passport card. They may require a driver's license and car registration. I got my MOC title, but I'm struggling trying to find surety bond for financial responsibility or insurance coverage. How is everyone getting around this?
Well, where are you? Are you in the US? Okay, so if you're in the US, if you're driving on the roads, then you're going to need to have some ability. First of all, you don't put a car into a trust. You've wasted too much money on a trust that's more valuable than any car, unless you have a $500,000 Ferrari. So be really careful. Don't put a car into a trust. Just get insurance on it. It's cheaper all around because even if the trust owns the car, it still needs to have registration and license and insurance if you're in the US, unless you really want to go out on a limb of that process of not working in the system. So be really cautious. Never put a liability into a trust, especially if that trust has an asset in it. So if a car goes into a trust with a house in it and the car hits something, then it's possible that that trust could be sued. So be really careful. No liabilities in with an asset. Okay?
Okay,
Anybody else?
final question. One
Okay.
last one from Tracy. What type of deed is used to transfer with the county?
Probably a quit claim deed. A county, if the county is really helpful, then they should step up and help you with that. Most county people are. And also when you go, here's a point. I've had a couple of people say, the notary won't notarize the whole document. I say the notary is not supposed to notarize your whole document. The notary is only supposed to notarize your signature, either as grantor or trustee or whatever. Do not tolerate a notary that says, I won't do this because I have to, I can't, I don't believe this document. They're not there for that. They're not judge on the document. They're there to notarize your signature. So be aware of that. That's a gift, and just speak up if they don't want to do that. I've been fortunate here. I've had 2 notaries. Not a problem anymore. Okay, any more? We can go on. I'm open. Anybody wants to hang
Okay.
out.
Everyone's thanking you very much, so I have to say that. Lots of thanks in the question chat. One more from Sister Love. Could you do separate trusts for each thing, like a car trust, a house trust? Let's see. Don't put all your eggs in one basket. So like you
Well,
said, yeah, go ahead.
it depends on your eggs. I mean, if you have a couple of eggs, if you have a house and some gold or some cash, then you can have one trust. If you all of a sudden, if you for some reason you've got a lot of money and you've got multiple houses, or maybe you have do rental properties, and so you have a number of houses. In that case, I'd start to look at separating every house into its own trust. There, the value sticks, and it will value and increase significantly. And also, when you put it in the trust now, let's say you've had that rental apartment for a number of years, it will go in at the rate it is, at the rate you bought it, not at the rate, the value of it now. Excuse me. It'll go in at the value as it is now rather than what you paid for it. So when you sell it, it will have the new value. And so it won't cost you as much in any kind of land tax. So be aware of that, how the BIC trust will help with your property and how to move it with less tax. So multiple trusts, when you start to have multiple commodities, if you have $100,000 in gold and silver, then maybe yes, cut a check for that and get a good safe. And that should cover it. But just be aware, you don't need it for everything, but be specific. And if you have questions on what things that would be good to put in a trust and what would not be, then send me an email.
Okay. We want to thank Eric. He was the one who initiated the recording so that all this good stuff was recorded. And
Great.
it looks like, let me just double check. Steve, much appreciate your time and knowledge. Question was not answered on American Passport Program. Does BIC still create them? He's just still asking about them.
Just go to the BIC and ask them. That's not my department. There'll be somebody there and they can say, yes, we can help. And this is who to go talk to. Okay.
Okay, that's it. Thank you, Randall. Thank you, Randall.
Thank all of you. I'm really grateful. I really am grateful that all of you have come to listen to me spout off. And I hope all the things that I say are meaningful in many ways. So aloha and see you next time.
Aloha.